Testimony has resumed this week in two racially charged trials in Georgia. Prosecutors are calling witnesses to take the stand in the trial over Ahmaud Arbery's death. Gregory McMichael, his son Travis McMichael, and neighbor William Bryan are accused of murdering the 25-year-old black man last year. Last week, prosecutors showed video of the suspects using trucks to chase down and confront Arbery as he was jogging. Arbery was later shot during a struggle. Attorneys claim their clients acted in self-defense, wrongfully believing Arbery was behind a series of break-ins. Prosecutors argue the men's actions were baseless. And in Wisconsin, a survivor is expected to testify in the second week of Kyle Rittenhouse's trial. The 18-year-old is accused of shooting three men, killing two of them during a protest over the police shooting of Jacob Blake last year. On Friday, a witness said victim Joseph Rosenbaum was acting belligerently but did not pose a threat to Rittenhouse. The suspect and the men he is accused of shooting are all white. However, the case has raised polarizing questions about racial justice, policing, firearms, and white privilege. For more on these cases, let's bring in CBS News legal contributor and Loyola Law School professor, Jessica Levinson. Hi, Jessica. Great to see you. So let's start with Georgia, where three white men are charged with killing Ahmaud Arbery, a 25-year-old black man. The defense team is holding on to acts of self-defense as their strategy. So how do they move forward with those claims without any proof that Arbery was a burglar or presented any threat to them?
Well, they move forward really relying on what Georgia's law was at that time. They move forward, I think, based on a two-step defense. First, they'll say, we had reasonable suspicion, which is a pretty low standard, frankly, that there was a felony, that there was a burglary here, and therefore we could perform a citizen's arrest. And then they'll say, as events escalated, we could invoke the defense of self-defense, that was also reasonable, given that, and they'll say Arbery looked like he was moving his hand towards his waistband, that maybe he was grabbing for a gun. So it's really that two-step process. I think it's important for people to know that Georgia has actually changed its laws in part as a result of what happened in this case. But of course, the prosecution and the defense can still rely on those old doctrines, the citizen's arrest doctrine, which has been changed, and the self-defense doctrine. And that's really what the defense case hinges on here.
Interesting. Okay, so let's look at the other side. The prosecution has mounting evidence in their case. Who are they calling to the stand?
So the prosecution is really, I think, largely going to depend on the videos as well. They're going to look and say, Mr. Arbery was chased for 5 minutes. They're going to look and show what happened with the two trucks, three men and two trucks who were chasing this man. And they'll say he was chased for 5 minutes. They really attempted to falsely detain him, and they were the ones who escalated the situation. They're going to say it wasn't reasonable to assume that they could have used self-defense. They were the ones who created the situation. So in both of the cases we're talking about today, a lot of reliance on the video evidence here.
And let's pivot now to Kyle Rittenhouse's trial, Jessica. Today, a man who was allegedly shot and wounded by Rittenhouse took the stand. What did we learn from him, and how do you think his testimony has been received so far?
This was hard testimony. He was very emotional. He said that I went there to support my First Amendment rights. He said, I'm a medic. I was there helping people on either side. He was really there to help the prosecution to say that Rittenhouse created the situation, and he can't then claim because he escalated the situation, again, similar to what I just said, that he could use self-defense. And I think the prosecution is really going to say Rittenhouse was young, was inexperienced, and he couldn't adequately assess that he should be using self-defense, that he wasn't reasonable. He was, in fact, seeing events not as a reasonable person would because of his youth, because of his inexperience. And I think the prosecution's witness today, the survivor, really emotional testimony. He was saying he lost 90% of his bicep. He lives this and breathes this every day. It's got to be hugely impactful for the jury.
Wow. And, Jessica, you mentioned Rittenhouse's age. And of course, he was 17 when these events occurred. Legally, he could not own a firearm at that age. So is his youth going to help or hurt him in this case?
I was just talking about this with a colleague because I said, in preparation of talking to you, it seems like the prosecution is hinging so much of this on he couldn't adequately assess self-defense. But as a juror, you could look at this and say he was a young guy. Maybe he thought he was doing the right thing. Maybe it was misguided. But you risk having a juror that feels some sympathy or empathy towards Rittenhouse. I'm not saying that that's what's going to happen, but by continuing to emphasize he's young, he's inexperienced, that really could potentially go both ways, I think.
But then could he face separate charges, firearm charges?
He is facing those charges.
Okay.
He is facing, in addition to the other charges, that he could not lawfully possess a weapon because he was at the time underage. Those were filed here.
Right.
Yeah.
Okay. So, Jessica, looking at these two trials, what are the parallels that we begin to see, and how challenging was the jury selection process for both of them, as well as the particular laws of where these incidents took place?
Oh my gosh, we could do a full seminar on all of the issues at play in these cases. And so jury selection, obviously hugely important in both cases, really difficult also to make sure that you have a jury of your peers. Now, in terms of the issues at play, obviously race. I mean, in both cases, race just pervades what's happening. Now, obviously different cases, but against the backdrop of this very serious reckoning in terms of racial injustice that our country is going through. In both cases, really struggling with the doctrine of self-defense. And I think in both cases, struggling with whether or not our legal doctrines, or maybe not whether, but how much our legal doctrines can be used to really kind of support racial bias. In both cases, I think what we're looking at is prosecuting people who, frankly, I think the prosecutors will say they were making their assessments based on racial bias, whether it be the person they actually killed or whether it be the backdrop of what happened in that case.
Very interesting. Jessica Levinson, we could talk about these cases all day. Thank you so much for joining us. We appreciate it.
Thank you.